So the $54.4 million is the federal match has yet to be approved by CMS for our indigent care dollars. So it started, we flagged it in 2013, it expired in 2014. So last year we only received half the dollars that we were anticipated receiving for indigent care. And so far it hasn't been reauthorized, so we will have a, if it's not reauthorized, it will be 50% going forward.
So the other factors that you mentioned would be on top of this, is what you're saying?
Exactly. There's what we call hidden cuts. So we have the indigent care funding, we have other things like minimum wage, Health Republic, all these things compounded, and at the same time, what new dollars were out there last year weren't available to us. Even though the rhetoric is we're the cornerstone of right sizing and reimagining healthcare delivery in New York.
Thank you.
Thank you. No other questions?
Thank you.
Thank you very much. Next. Put on the mic. Steve Sanders, Agencies for Children Therapy Services. Good afternoon, Steve.
Good afternoon. You're still here. I don't just mean today. You're still here,
Yeah,
which is heartening. Good afternoon, ladies and gentlemen. Chairman Hannan, Chairman Farrell, and I can't help but observe Chairwoman Young. I believe that you are the first woman in the history of the state of New York to serve as the chair of either Assembly or Senate's fiscal committees, and that's quite a milestone. I congratulate you. It's terrific.
Thank you very much, Steve. Always good to see you.
I'm here again this afternoon to talk about early intervention. I'm the executive director of the Agencies for Children's Therapy Services. ACTS members provide about 60% of the early intervention services statewide. The governor has essentially made proposals in 3 areas of early intervention. The first area is of tremendous concern, and I want to address most of my remarks towards those proposals, in which the commissioner earlier today had an interesting exchange with Assemblyman Abenante. One set of proposals that the governor, through the Department of Health, has made deals with changing the method and the circumstances that toddlers and infants will be evaluated for eligibility into the early intervention program. What the governor basically wants to do is to set up a new layer of bureaucracy. He wants to do pre-evaluations before the evaluations. He calls it pre-screening. The commissioner, in his exchange with Assemblyman Abenante, insisted that that will somehow speed the process along, that kids will somehow get evaluated more quickly, get referred more expeditiously, and receive their services on a more timely basis. The best I can say about those remarks is that the commissioner is wrong. It doesn't even make sense, even if you don't really understand the process, it doesn't really make sense to a layperson to hear that a new layer of bureaucracy to evaluate a child is somehow going to get that child into services which that youngster desperately needs more quickly. Doesn't make any sense. The commissioner is wrong. There are 2 other things about that proposal that are very troubling. Not only does the commissioner want to have pre-screening of infants and toddlers, in some cases before they will get evaluated and then services will begin, the governor also proposes that in some cases evaluations are not necessary at all, that you can just take a youngster's prior medical condition and take the records that are associated with that prior medical condition, which in some cases may have nothing to do with a disability, and use those records as a substitute for evaluations. Well, I have real serious concerns about that because those medical records and those observations by some health professionals who are not trained to identify and really target developmental disabilities very often will miss symptoms that only qualified evaluators are able to discern and then to make recommendations about services. So using a set of medical records as a proxy for determining eligibility is a real problem. The third thing in this part of the governor's proposal, which is very troubling, is that the governor takes out altogether, he eliminates multidisciplinary evaluations. In other words, evaluations right now for a child who is suspected of having a learning delay or a developmental disability is done on an across-the-board basis. Speech, occupational therapy, the variety of delays a youngster can have. That's multidisciplinary. For some reason unknown to me, the governor brackets out multidisciplinary and just says, when it's appropriate, an evaluation will take place. Well, I think that is almost ensuring that this youngster or many youngsters are not going to be able to receive all of the services that is appropriate to that youngster. Why would the governor do this? Well, you know, the fewer kids who get referred to early intervention, the less money that the state and the counties have to pay. That's the wrong prescription. That's the wrong way to go. Every study that has been done about early intervention makes the same conclusion, which is that when these very young kids, age 0 or 1 or even 1 or 2 months old to 3, receives early intervention, that eliminates more costs that will be incurred by school districts, in preschool special education, in school-age special education, far more expensive modalities of services. Those expensive services are not needed in some cases, or at least the disability is lessened or remediated through early intervention, saving the state money. Early intervention is not a cost driver. It is a cost saver. And when we try to skimp on providing adequate resources for early intervention, we pay the price later. More importantly, these youngsters and their families pay the price with a lifetime of more complicated disabilities than they might otherwise have had were it not for the fact that they did not get the early intervention they needed. Let me quickly mention the 2 other areas that the governor does, I think, make constructive recommendations. He does recommend a 1% increase in the administrative cost for processing early intervention claims for agencies. This doesn't make up for 20% cuts over the last 4 or 5 years. It doesn't make up for the fact that there's been no increase for early intervention in well over a decade, but it's a start. And I'm pleased at least to see the needle going in the right direction with respect to that. One other area that I think is important to note, the governor makes some changes in the insurance law, which would require that commercial insurance companies adjudicate the claims faster, hopefully pay more of the early intervention claim. Currently and historically, this percentage has never changed. Commercial insurance pays 2% of the $600 million which is claimed in early intervention every year. Let me repeat that. Commercial insurance pays 2% of the $600 million in early intervention claims that are made each year by the nearly 70,000 youngsters in early intervention. That is shameful. It's shocking. And I'm pleased that the governor is trying to take steps this year to have commercial insurance not only adjudicate the claims faster because they take far too long with far too much bureaucracy in determining whether a claim will be honored, but they pay far too little. And anything that we can do to help ensure that commercial insurance companies are paying their fair share not only saves the state money, but it also is the right balance. It still preserves the autonomy for private insurers, but it also has the right balance of autonomy and, I think, responsibility. So, to conclude, I would say to you that the governor's proposals to amend the public health law are wrong. This legislature considered similar proposals in 2013. You rejected them for the right reasons. They didn't get better with 3 years of age. They were wrong in 2013. They're wrong in 2016. I hope you'll reject them again. And his proposals to amend the insurance law, I think, are things you should seriously consider, because commercial insurance needs to be stepping up to the plate and honoring a much higher percentage of those claims. I thank you very, very much for your time and your consideration always.
Thank you very much, Steve. Questions, Senator?
Yes, Senator Kruger.
Haven't seen you in the hood for a while, Assembly Member.
Good to see you again,
Nice to see
Senator.
you. Two quick questions, just because of the time frame of the day. I agree with you. It's unbelievably disturbing to hear that private insurance is only paying 2% of the cost. Any number of topics came up today where we were disappointed the Division of Financial Services wasn't here. Do you think insurance companies are actually violating state law or the policies that they have written?
To the best of my knowledge, they are not. They have an obligation in law to honor what is the provisions in their particular policies. I think the problem is that their policies are so weak in early intervention. There's very little in their policies that they ever really have to pay. Absent the legislature making a stronger statement that early intervention has to be a covered policy, absent that insertion in the law, it's been my experience, with apologies to some very, very good insurance companies. I know there are some, but it's been my experience that they are very, very good about avoiding their responsibilities, not just in early intervention, but in other areas in paying claims that really they're accepting premiums, they're accepting a lot of money for these policies. They're not so good in paying out when it comes time to pay out. Are they violating the law? I can't say that they are, but certainly I would be in favor of a stronger statement in law that they have to fully cover early intervention.
I agree with you. Thank you. And I think a follow-up from a much earlier question by one of my colleagues, I think to the Department of Health, concerned that providers of early intervention services have dropped out but still appear on lists because
Yes.
they're not removed from the list. Can you talk briefly about whether you agree with that we have a much smaller universe of people participating?
That is an accurate statement. There are a number of early intervention service providers who, in the last 3 years in particular, have left the program, but in other words, they're not accepting any more cases, or very few cases, but because in some instances they are still owed money from services that they provided in 2014, 13. They are not withdrawing officially from the program. They're no longer providing services because it has become so very, very complicated and so very, very expensive for agencies or individual providers to do the work the counties used to do. You have to remember that prior to 2013, counties were billed for the services, and counties paid the providers up front, and then the counties had to collect from Medicaid or commercial insurance or other sources. That all changed in 2013. Now it is the responsibility, pretty much, of the providers and the agencies to go chase the insurance companies, to go chase Medicaid, to go chase the other parties in order to be able to be reimbursed. It isn't just that it is more difficult. It is tremendously time-consuming, and a lot of providers simply do no longer have the time to be billers, accountants, and also service providers. They signed up to be service providers, and now they're told that half of their time has to be spent chasing down those people who have responsibility to pay them. The fiscal agent was brought into play in 2013. In some areas, they've done a good job in helping to expedite this morass, but it has still fallen largely on the providers to try to be paid for services that they have provided. And it's just too time-consuming, and a lot of them have left the system, and it's a pity.
Thank you for your testimony.
Thank you. Further questions? Mr. Avenatti.
Thank you, Mr. Chairman. Thank you, Mr. Sanders. First, I don't know if the questions I'm going to ask are within your area of expertise. Forgive me if they're not. But there are some things in this Article 7 that I'm trying to understand, and frankly, I didn't get much assistance from the Commissioner this morning, but perhaps you can help me. I see in here, one place there's something that says a family-directed assessment. It says, if consented to by the family, in order to identify the family's resources, priorities and concerns, and the supports necessary to enhance the family's capacity to meet the developmental needs of the child, the family shall be voluntary. But basically what it looks like, I mean, from one point of view, you can look at this and say, this is great because we're going to assess what the family needs and we're going to provide more. From the other way, you can look at this and say, this is violative of the approach that Governor Mario Cuomo took, which said it doesn't matter what your family resources are. We're going to bring the state's resources to help each and every child. Do you read this the way I do, that this is an attempt to cut back and say your family is richer than some others, and therefore you're going to have the responsibility to take care of this child, and we're not going to give you the services you need?
Well, I certainly hope not. I'm frankly somewhat baffled at that language as well, because state law currently and federal law, IDEA, guarantees that a family that has a child that is in need of early intervention, not because the family says so, but because that child has been evaluated. There has been what is called an individual family service plan, an IFSP, that has been developed, and that IFSP has the participation of the county that the child resides in, so county officials are involved in that, the development of that IFSP. The evaluator is involved in the development of that IFSP. The family can have representation on that committee. And once the IFSP is developed and identifies the services which that youngster needs, federal and current state law provide that those services will be given to that child at no cost. Now, I'm not sure where the governor is going with this language, which is one of the reasons why my recommendation and advice is that the changes in the public health law that the governor has made, almost all of which we've seen before that have been rejected, ought to be rejected again. There are certain things in this program that are simply not broke. And the governor ought not try to fix that which is not broke. One of the things that is not broken is the parents' guarantee and ability to have their child evaluated by an evaluator of their choice based on an approved list. And once their child is evaluated, then the process kicks into motion. We ought not be placing impediments between the family and services, and the pre-screening places impediments. I'm sure that the commissioner could, if he were here, could cite one or two examples of, well, if we have pre-screening, I can show you how that will speed things up. And I bet he's right. There might be one or two cases where you could posit an example where that could happen. But in the main, if we are now placing a new bureaucracy, a new layer of responsibility between when the child is actually diagnosed or evaluated and services begin, it's going to delay services. And every clinician and every medical study that has been done, and I know you're aware of many of them, I know each of you are, every one of those studies indicate that the cognitive development of that child's brain, is such that if services are not brought to bear at a particular age, if you wait literally weeks or months longer than you might otherwise have waited, the synapses have closed. There are certain disabilities that are much harder to remediate even if you wait a few months. At that age, when a child is 6 months old, 8 months old, 9 months old. So time is of the essence. Time is very much of the essence, and anything that will slow down that process is dangerous and wrong.
Okay, there's another section in here that talks about a healthcare clearinghouse. It said providers shall enroll on the request of the department or the department's fiscal agent with one or more healthcare clearinghouses. I can't find in here a definition of, maybe you know what the healthcare clearinghouse is, and what is this about?
This is something that has been done on a voluntary basis, whereby there are services that are provided or organizations that exist that will help to expedite the claims. And you go through that clearinghouse, and they help the fiscal agent to expedite the claims. They try to sort
But
out...
who pays for this?
Excuse
the
me?
providers will have to pay for this?
No, the providers generally... no, to my experience, the providers do not pay for this at all, no.
Who pays for them?
I presume the state does.
That's not clear in here. Okay.
No, Assemblyman Abenante, if you find a number of references that are not explicit, then your reading is no different from my reading. I don't worry about the clearinghouse because I've seen it in operation on a voluntary basis, and at worst it's benign. It may actually, in some instances, be a helpful
But shouldn't that
tool.
be what the fiscal agent is doing? Shouldn't they also be a clearinghouse?
Well, I'll tell you something. When this legislature approved a fiscal agent back in 2012 to go into effect in 2013, it was your expectation and our expectation, the providers, that the fiscal agent, in fact, was going to operate in such a manner that you submitted your claim to the fiscal agent. The fiscal agent then acted as an intermediary between the provider and the insurer to make sure that the provider got paid. It hasn't turned out.
So then instead of requiring the fiscal agent to do this work, we're now adding another layer in here by some private companies that are healthcare clearinghouses.
Well, if you ask my opinion, I think that it is a task that the fiscal agent should have been doing. I don't think it was ever part of their contract to do that particular work. And in an honest answer to your question is I don't know who funds the clearinghouse, other than it is not my understanding that is a cost that has been absorbed by providers.
And lastly, do we have any numbers out there of how much money is still left over owing to providers that they haven't caught up yet? Is there any number out there? The Public Consulting Group, which is the fiscal agent, puts out reports periodically. I believe that their last report, which goes back just a few months,
indicated that there wasn't, if recollection serves, there wasn't more than 12 or $14 million that was still outstanding, which isn't bad. When you talk about a $600 million annual claiming in early intervention. But one of the things that the commissioner said that was very misleading, in answer to one of your questions, Assemblyman, is that he said, well, providers get paid on average now every 2 weeks or so, their claim. Their claim is paid about every 2 weeks. That just isn't accurate. There are some claims that are paid very quickly. Claims that go to Medicaid tend to be paid rather quickly. Claims that bypass Medicaid or even commercial insurance, if the family is not insured, that goes directly to an escrow fund that is funded by the counties and ultimately the state, they share it about 50-50. Those claims get paid pretty quickly also. The claims that go to commercial insurance can still take weeks and weeks and weeks, indeed months and months and months, even before they're adjudicated. And in most cases, they pay very little of the claim anyhow. It takes them a long time to adjudicate the claim, and they pay very little. That's one of the reasons why I think that the governor's recommendations to bolster the insurance law are good recommendations. It will help, I think it will help to expedite the claims, and I think it will help to get insurance to be paying more of their fair share.
But the whole claim is awaiting the insurance company's yes or no.
That's correct. Once your claim
Just for
goes to
2%.
commercial insurance, even if they're only going to pay a small part of it, none of it gets paid until the payer of first resort, commercial insurance, decides whether they're going to pay and how much they're going to pay. So consequently, you've hit the nail on the head. You have a claim of $1,000, of which that commercial insurance company is only going to pay $50. The other $950 gets held in limbo until the commercial insurer decides that they're only going to pay $50 or less.
Thank you. Thank you very much.
I thank you all once again.
Thank you, Assemblyman.